We will now move into the traffic law section of the pre-basic course. I want to make you aware that at the end of this section there will be a short scenario provided to you. We ask that you go over this scenario with your field training officer in order to get a better idea of how to address specific issues that you may encounter during a traffic stop. Traffic law in Indiana is codified in the Indiana Code Title 9. So if you look at the example in front of us, Indiana Code 9-21-5-2, you see tax as in title, article, chapter, section. In this example, title would be 9 motor vehicles, article would be 21 traffic regulations, chapter would be 5 speed limits, and section would be 2 maximum speed limits. In discussing traffic law, one of the important concepts that an officer needs to be aware of is the term traffic offense. That can be found in Indiana Code 9-13-2-183. And under Indiana law, a traffic offense means a violation of a statute, an ordinance, a rule, or regulation relating to the operation or use of a motor vehicle, and any violation of a statute, ordinance, a rule, or regulation relating to the use of streets and highways by pedestrians or by the operation of any other vehicle. When we discuss traffic offenses, more often than not, we are talking about civil infractions. There are a few examples in which traffic offenses are criminal, and we will discuss those later. However, most traffic violations are civil, and therefore that means they are only punishable by a fine, and that a person cannot be placed in jail solely on the basis of a traffic infraction alone. If an officer is wanting to make a traffic stop, the officer only needs to show that he or she had a good faith belief that the person driving committed a traffic infraction. And this is codified in Indiana Code 34-28-5-3. It's important to note that an officer may not randomly stop vehicles, but in order to stop a vehicle, the officer must be able to articulate and demonstrate that he or she had a good faith belief that the driver committed a traffic infraction. If a traffic infraction is challenged in court, the state's burden is only a preponderance of the evidence. That is different than in a criminal case. In a criminal case, the state's burden is beyond a reasonable doubt. The preponderance of an evidence standard is merely a more likely than not standard. So the court will evaluate the traffic infraction on whether it's more likely than not that the person committed the infraction. Once an officer has a good faith belief that a person has committed a traffic infraction, the officer may make a traffic stop. During the traffic stop, the person must give their driver's license if it's in their possession. If they do not have it on their possession, the person must give their name, address, and date of birth. Failure to give that information as the driver could result in being charged with refusal to identify, which is a Class C misdemeanor codified in Indiana Code 34-28-5-3.5. It's important to remember when thinking about refusal to identify that this statute only applies to traffic stops, that a person can only be charged with refusal to identify if they were the driver of a vehicle. So once the officer makes the stop, the officer may order the driver and or any passengers out of the car. The courts have found that these actions are de minimis intrusion and do not violate the Fourth Amendment. If the officer is required to use force to remove a person from the car, the court will consider the needs of the law enforcement to have the person exit if force is used to remove the person from the car. Once an officer has removed a person from the car, the officer may perform a pat-down if the officer has reasonable suspicion that the driver and or any of the passengers are armed. Once an officer has made a traffic stop on a vehicle for violating Indiana's traffic law, the officer may issue a UTT, a Uniform Traffic Ticket, and that's found under Indiana Code 9-30-3-2.5. A UTT is often referred to as an e-citation as it is an electronic traffic ticket. It may be printed at the site of the stop or the traffic violation. However, the officer must inform the driver or the person receiving the ticket if they must appear in court and give them that date and time of their required appearance. The officer shall indicate on the ticket whether the officer served the person a copy or it was sent in another manner. Digital signatures by both the officer and the driver are admissible in court. and those tickets may be electronically transmitted or submitted to the court. Once an officer has issued a UTT, there's vital information that must be included on that citation. A UTT must include all information needed concerning a traffic arrest or citation. That information will include information about the vehicle, the time and place of the alleged offense, and the violation. It's important that the officer remember to completely and neatly fill out this information, and that an officer should take notes on every ticket that he or she issues, so that information will be available if and when the officer is called to testify. Each officer should take affirmative steps to discover the expectations of the prosecuting attorney in their county, as well as the judges in the court in which their ticket will be filed. Any person, including the police officer, may be found guilty of criminal contempt if any information and summons is disposed of in an improper or unauthorized manner. As you enforce traffic law, one of the areas that you're going to need to know is towing and impounding of vehicles. In Indiana, there are 3 primary ways that a car can be towed or impounded. The first is statutory authority. The second is community caretaking function, and the third is abandoned vehicles. Under the statutory authority, we have included the code site for many of the areas in which an officer is statutorily allowed to tow a car. The first is no right to possession of the vehicle. This is a situation when someone other than the owner has a vehicle and has no right to possess that vehicle. The second is not properly registered or properly plated vehicle. The third is unsafe equipment or mechanical condition. The next is the driver refuses to move an unattended vehicle from a highway. Usually in this situation, they will have been asked to remove the vehicle from the highway and refuse to do so. The next, which is similar, is vehicle unattended on a bridge or on a causeway or in a tunnel. And finally, the abandoned vehicles. When it comes to towing and impounding, it's important for officers to be aware of the community caretaking rationale or community caretaking function. This allows an officer to impound or tow a vehicle because that vehicle creates a potential hazard to public safety. This is a 2-pronged test that the state must demonstrate in order for the vehicle to be impounded or towed. First, the officer must have a belief that the vehicle poses a harm or a threat to the community and that towing that vehicle is consistent with the standards of sound policing. And the second prong is that the decision to tow or impound the vehicle was in keeping with established departmental routine or regulation. And generally speaking, when an officer decides to tow or impound a vehicle under the community caretaking function, the decision to tow is generally a matter of common sense. Situations such as car accidents where a car is not movable, the car is impeding business or traffic, it interferes with the property of another person, the car has no proper license, the driver of the vehicle has no proper license, and the vehicle's broken down in the middle of the street. So it's generally speaking, common sense would apply to these situations and looking at whether or not to tow based on this community caretaking function. There are also agency-specific reasons that allow an officer to tow or impound a vehicle. One of those is towing incident to arrest. It is important that an officer knows their agency's policy and procedure regarding towing incident to arrest. If a tow is challenged in court, the court will evaluate whether the officer reasonably followed the existing agency policy to tow. This also includes the agency's policy for inventory searches after a tow incident to arrest. Finally, an officer has the authority to tow a vehicle if that vehicle is determined to be abandoned. Under Indiana law, a vehicle is considered abandoned if it is on public property illegally, it's on public property and not moved for 24 hours, the vehicle is on public property but creates a hazard, so this would be similar to the community caretaking function, A vehicle is on private property without the consent of the owner for more than 48 hours. Generally, this is a situation in which a person's parked in a parking lot or some other place like Walmart where they could park there, but the vehicle hasn't been moved for more than 48 hours. The vehicle is on private property continuously and visible from the public property for more than 20 days. It's important to remember that in order to tow under this continuously visible for more than 20 days, that the vehicle has to be more than 3 years old and mechanically inoperable. If an officer sees a vehicle that he or she believes to be abandoned, the officer must tag the vehicle in accordance with Indiana Code 9-22-1-11. So if an officer sees a vehicle that they believe is abandoned, the officer shall attach in a prominent place, so generally on the windshield or the driver's side window, a notice tag containing the date, time, and officer's name, the agency address and telephone number to contact for information, and information indicating that if the vehicle is not removed, it will be towed. So the person would have 24 hours to remove the vehicle on a public highway and 72 hours on all other property. When evaluating whether a vehicle is abandoned, it's important to know that there are specific vehicles that are excluded and cannot be considered abandoned. Those vehicles include a race car if it is operable, a vehicle owned by an active duty member of the military, so this would be a person that would be on deployment or is actively engaged in their military duty, vehicles for sale on a sales lot, vehicles that are being held at a scrapyard, vehicles that are registered as antique vehicles, off-road vehicles, and golf carts. Moving on to emergency lights. Under Indiana Code 9-19-14-5.5, only specific vehicles are allowed to have red, red and white, or red and blue lights on their vehicle. Those vehicles include police vehicles, emergency vehicles, and funeral escort vehicles. When an emergency vehicle is either using its lights or its sirens, that authorized emergency vehicle is exempt from most traffic laws if it is responding to an emergency call, is in the pursuit of an actual or suspected violator of the law, or is responding to a fire alarm. It is absolutely important to remember that even in responding to an emergency situation, the driver of an emergency vehicle must use due regard for the safety of others. This is codified in Indiana Code 9-21-1-8. The move over law states that when an emergency vehicle is giving either audible signal by siren or displaying flashing red, red and blue, or red and white lights, all other motorists must yield to the right-of-way of that emergency vehicle, immediately drive to a position parallel to and as close as possible to the right edge or curb of the highway, clear of any intersections, and stop and remain stopped in that position until the authorized emergency vehicle has passed. When a motorist approaches a stationary emergency vehicle that is displaying red, red and white, or red and blue lights, the driver must either move over and change lanes or proceed cautiously, slowing to a safe speed of at least 10 miles below the posted speed limit. Indiana Code 9-21-8-35 states that failing to yield the right-of-way to an authorized emergency vehicle with its sirens or lights flashing can result in a Class A infraction. However, that Class A infraction may become a Level 6 felony if the violation results in serious bodily injury, catastrophic injury, or death to another person. When a motorist approaches a stationary recovery, utility service, solid waste hurler, road maintenance, surveyor, or construction vehicle with flashing amber lights, that motorist shall make a lane change into a lane not adjacent to the vehicle. If they are unable to do so, they must reduce their vehicle's speed to at least 10 miles below the posted speed limit. Failure to do so can result in a Class B infraction. If a motorist approaches a disabled stationary vehicle with its flashing hazard lights, that motorist must make a lane change into a lane not adjacent to the vehicle. If they are unable to do so, they must reduce their speed to at least 10 miles below the posted speed limit. Failure to do so can result in a Class B infraction. Moving on to Indiana's seatbelt laws. Under Indiana Code 9-19-10-2, all occupants of a vehicle must have a safety belt properly fastened when the vehicle is in forward motion on a highway. It's important to note that any citation issued will be issued to the individual that failed to wear a seatbelt and not the driver. A child under 8 must be properly fastened and restrained by a child restraint system. If a child is at least 8 and over 80 pounds, but less than 16, they must be properly fastened in a seatbelt. Any citation issued for failure to place a child in a restraint system or failure for a child under the age of 16 to wear a seatbelt is given to the driver of the vehicle and not the child themselves. This can be found in Indiana Code 9-19-11-3.6. There are also exceptions to the seatbelt laws in Indiana. Those exceptions can be found in Indiana Code 9-19-10-1. Indiana Code 9-19-10-3.1 states that officers may not operate seatbelt checkpoints to detect and issue seatbelt violation citations, and that a vehicle or its passengers or its contents may not be searched solely as a result of being stopped for a seatbelt violation. However, if an officer develops reasonable suspicion of criminal activity during a seatbelt stop, the officer may continue with that investigation. Indiana's laws on vehicle front lamps, often referred to as headlights. A motor vehicle must be equipped with at least 2 headlamps that are either white or amber in color and located in the front of the vehicle and visible 100 feet in normal sunlight. A vehicle cannot have more than 4 front lamps or headlights at any one time, and the headlamps must be on from sunset to sunrise and visible 500 feet from the vehicle. A vehicle cannot have flashing lights as its headlamps, and this is codified under Indiana Code 9-21-7-11. Tail lamps. A vehicle must be equipped with at least 2 functioning tail lamps on the rear of the vehicle or the attached trailer, and may only emit a red light that is plainly visible from a distance of 500 feet to the rear of the vehicle. A vehicle must also be equipped with functioning turn signal lamps that can only be red or amber in color. The only exceptions to this is signal lamps, which may be white or amber, the license plate lamp, which must be white, and backup lamps, which may also be white or amber. Windshields. Indiana Code 9-19-19-1 states that all vehicles other than motorcycles must be equipped with a windshield, and that the mere presence of a crack is not a violation unless that crack is a 4-inch square area that obstructs the driver's view, and that signs, posters, sunscreens, and other materials are allowed on the windshield so long as they do not obstruct the driver's clear view of the highway. Indiana has a catch-all provision for unsafe vehicles, and it can be found in Indiana Code 9-21-7-1, and it states a person may not drive or move on a highway a vehicle unless the equipment upon the vehicle is in good working order and the vehicle is in a safe mechanical condition that does not endanger a person on the highway. Moving on to registrations and licensing. Registration. A vehicle may not operate on a highway unless the vehicle is 1, properly registered, and 2, the owner of the vehicle displays proof of registration upon request by a police officer. Please note that it is no longer required that the registration be signed. If a person fails to register a vehicle or fails to display proof of registration, such action is a Class C infraction. In order for a vehicle to be registered, the owner must show proof of title and proof of insurance to obtain registration. It's important to remember that unless a person is involved in a crash, the driver is not required to carry or provide proof of financial responsibility. However, failure to have financial responsibility on one's vehicle is a Class A infraction. Expired plates can be found under Indiana Code 9-18.1-11-2. Driving with expired plates is a C infraction. Proper display of registration. Registration plates, often referred to as license plate, is to be displayed on the rearmost part of the vehicle in a horizontal upright position in a manner that shows the registration expiration year in the upper right corner. The plate must be clearly visible and properly illuminated. A plate may not be displayed in the rear window of the vehicle. False and fictitious registration. A vehicle may not operate on a highway with a license plate that belongs to another vehicle. This often happens when someone buys a new car, they'll place their old plate on their new car. This is not allowed. a fictitious registration number, or a sign or a place card bearing the words license plate applied for, in transit, or license plate stolen, or something similar, often referred to as homemade plates. Lost or stolen plates. If a plate is lost or stolen, the person to whom the license plate is registered to shall notify law enforcement either where the loss or theft occurred or where the car is registered and the person lives, that the original license plate or other proof of registration has been stolen. A person may not make a homemade plate for display in the event that is lost or stolen. The person must get a new plate before the vehicle may be driven. Enforcement actions with regard to improper registration. Under Indiana law, an officer may conduct random registration checks, commonly called running plates, without violating the Fourth Amendment of the U.S. Constitution or Article 1, Section 11 of the Indiana State Constitution. However, these registration checks must be done in accordance with IDAC's rules. Once an officer discovers a vehicle has operated without proper registration, the officer may take the license plate displayed on the vehicle into the officer's custody, take the vehicle into the officer's custody, cause the vehicle to be taken to and stored in a suitable place, or take any combination of these actions. Driver's license. Possession and display of one's driver's license can be found under Indiana Code 924.13.3, and it states an individual holding a permit or a license must have that permit or license in their immediate possession when driving or operating a vehicle on a highway. Failure to do so is a ticketable offense, and it is a Class C infraction. If a person has been cited for driving without a license, that person has 5 days to go to either the officer or the officer's agency to prove that he or she is in fact a licensed driver. This can be found under IC Code 924.13.6. If this person presents their driver's license to either the agency or the officer, the ticket will be dismissed or dropped. A person stopped by an officer for an infraction must either give their license if they have it in their possession, or their name, address, and date of birth. Failure to do so can result in the criminal charging of refusal to identify, which is a Class C misdemeanor and can be found under Indiana Code 3428.5.3.5. Misuse or false license or permit. A person who displays or possesses a fictitious, canceled, revoked, suspended, or altered license or permit, gives or knowingly permits the use by another individual not entitled to that license or permit, displays or represents someone else's driver's license or permit as their own, or sells, offers to sell, or buy or possess a driver's license or permit that has not been issued by the Indiana Bureau of Motor Vehicles or any other state, commits a Class C misdemeanor. However, the offense becomes a Class B misdemeanor if a person knowingly or intentionally counterfeits or falsely reproduces a driver's license with the intent to use it themselves or to permit the use of it by another person. The main difference here is that the license was counterfeited or falsely made. Operating a vehicle never having received a license can be found under Indiana Code 924.18.1, and it states an individual who knowingly or intentionally operates a motor vehicle upon a highway and has never received a valid license commits a Class C misdemeanor. However, this Class C misdemeanor can be raised to a Class A misdemeanor if the person has a prior unrelated conviction for operating without ever having received a license. Driving while suspended can be found in Indiana Code 924.19 if a person operates a motor vehicle upon a highway while the person's driving privileges, license, or permit were suspended or revoked. However, the offense can be raised to a Class A misdemeanor if the person knowingly operates a vehicle upon a highway less than 10 years after the date on which the judgment was entered for the prior driving while suspended, or the suspension or revocation was the result of the individual's conviction of a crime. However, the offense can be raised to a level 6 felony if the operation of the motor vehicle results in bodily injury, and it can be raised to a level 5 felony if the operation results in death of another person.